Joining us now to talk about the case and the closing arguments and some of the things that have taken place is Lance LoRusso, attorney, former law enforcement officer, and author of the book When Cops Kill. Lance, a pleasure to talk to you, sir. How are you?
Thank you for having me on, Steve.
It's my pleasure. And we should point out that in your role, you represent police officers who use their weapons in a lethal manner during police incidents, correct?
Exactly. Actually, the profits for When Cops Kill are going to support law enforcement charities.
Very good, very good. And is that any of that with New York City at all, cops, or not?
Anywhere. Matter of fact, a lot of it's going to either the Fraternal Order of Police Vest Fund that buys vests for officers don't have them, or huntingforheroes.org, where we take care of law enforcement officers who are disabled in the line of duty.
Well, that's great, and I'm glad you misinterpreted my question, which was my fault. I'm glad to find out where the money's going. But I meant, have you represented any officers in New York City for the PBA or anything that have been involved in shootings at all here in New York at all?
No, I have not.
Okay.
Actually, I grew up in Long Island, but I have not.
There you go. Okay. Oh, so you're probably a Rangers fan if you follow hockey, or an Islander fan for that matter, I guess. But anyway, so I want to talk to you. I don't know if you saw the closing statements by the prosecution, but they did focus on this profiling. George Zimmerman had a gun. He knew he had a gun. He profiled Trayvon Martin. He called him an a-hole, and he called him a blah blah. And he was going to take care of this on his own. And he, he profiled a Trayvon Martin, and he was a wannabe cop. He took a crime course, and he applied to the police force in Virginia. He was a wannabe cop with a gun, with a purpose. You think that's an effective, argument to make in this case?
No, as a matter of fact, I would describe the prosecutor's closing argument as, with one word, loud. It seemed like he started out yelling at the jury and finished up yelling at the jury. And a lot of the issues he was bringing up, obviously we can't see the jury's face, and we shouldn't on television, but I just don't believe that that's going to have a real heavy effect on the jury. They know what the facts are, and they know what they heard. And a lot of it was trying to pull snippets out of videos. I expect what the defense lawyers are going to say, all of those videos, all of those statements, every time he talked to the police, remember, he didn't have to tell them anything. They were completely voluntary.
No, absolutely. And I could ask you the same questions that the defense had asked expert witnesses and police detectives, and they keep saying that George Zimmerman, in the closing arguments, George Zimmerman lied. Oh, I'm sorry. I just went to a website, and it won't one of these commercials came up, so let me get out of here. But actually, what I was going to talk about was the fact that all right, let me get out of here. Okay. You hear that? Yeah, everybody hear the free entertainment? I'm trying to do a story on the prosecution star witness, where apparently in his closing arguments, he also said that he invoked Martin Luther King Jr. in sticking up for Rachel Gentile and the validity of her testimony, and that story apparently had a little link to it that played by itself. So now I don't have the story in front of me. But anyway, and I've lost my train of thought. So I'll give the guest name again: Lance LoRusso, attorney, former law enforcement officer, and author of the book When Cops Kill. Here's what I wanted to say: this profiling issue. To me, Al Sharpton and others have made profiling a dirty word. Profiling now equals racial profiling, and even racial profiling should not be a dirty word or a dirty term. It's a legitimate police tactic, like auto profiling or sexual profiling or gender profiling. If you stop someone just because they're black or Hispanic or white and harass them for no reason, that's harassment. That's illegal. That shouldn't be called racial profiling. Am I correct that profiling of all kinds, including racial, is a legitimate police tactic?
Well, absolutely. It's not just police. It's a legitimate tactic that everyone uses, and I think that's what's getting lost. I set up a lot of neighborhood watch programs when I was working with the police department, and I was the liaison for those programs. And I think what has really been a problem for people is people disagree why George Zimmerman followed or called or surveilled or whatever you want to call it, why he picked up the phone and said to the police, I think this person should be contacted by the police, and I think he's doing something suspicious. That is necessarily a subjective determination. We could put 100 people in a room, and 98 may not agree with him, but the whole purpose of Neighborhood Watch is if you see something that you believe personally, subjectively, is suspicious, call the police.
Yeah, no, absolutely. And we're told if you see something, say something. As it relates to terrorism or suspicious packages or a suspicious person. And again, and yet when something like this happens, when George Zimmerman sees somebody he doesn't recognize, someone who fits the profile, wearing a hoodie, but he doesn't call the cops and say, hey, there's this black guy. He just says someone's acting suspicious. They had to ask him what the race was. Then he said, I think he's black or he looks black, whatever. But the point being, there were robberies in the neighborhood. He had reason to be suspicious of people he didn't recognize walking around in the rain. This is what he saw.
Well, he also points something else out that's critical. He says that Trayvon Martin was walking on the grass right in front of a residence and not on the sidewalk. And Steve, look, here's the issue with this case that really all of the other issues have come down to. He was reporting information back to the police. He was doing everything he could to get the police to his location. People intent on committing a crime generally don't do that. But here's the crux of the case. Two essential questions when somebody uses deadly force. Law enforcement, non-law enforcement, this is it. Why did you start shooting? Why did you stop shooting? George Zimmerman, and it's a subjective belief, and a jury's going to have to decide whether it was reasonable, said that he pulled the trigger once because he believed his head was being pushed into the pavement. He was going to go unconscious. He said it felt like his head was going to explode. He was experiencing pain. He was being choked with his nose being cut off and his mouth being covered. He fired one shot, but what's critical is he states he believed he missed. That is not uncommon. And when cops kill, I interviewed a lot of officers. People say, why did the officer shoot so many times? So they're shooting to stop the threat. And a lot of times officers do not know that the round they fired was effective. But when George Zimmerman fired that shot and thought he missed, Trayvon Martin, in his words, leaned back and put his hands up and stopped the attack, and George Zimmerman stopped shooting. If he was really intent on killing someone, why did he only pull the trigger once, even though he thought he missed?
Yeah, no, absolutely. And then there's this argument, which I don't understand. People who are on the side of Trayvon or against George Zimmerman, I should say, well, why did, if in fact Zimmerman was yelling, why did the yelling stop after he shot him? And I say, in answer to that, and maybe you have a more expert type of answer, I say, well, wait a minute. Guy's getting his head pounded. He's getting beaten up. He's shouting, and then he shoots the guy. The pounding stops. So he stops, and plus he's in also a state of shock. Those two combined, of course you're going to stop screaming.
Well, it may even be simpler than that, Steve. He may even catching his breath.
That
you know, what the expert was talking about, after 30 seconds, we tell people to change their tactics. Even a person who is in excellent physical shape in a full-blown physical confrontation, has about 2 minutes of fight left in them. And after 30 seconds, that's why you hear people's voices differently. I've represented officers, and I represented an officer who shot someone who was, quote, unarmed, but he was trying to take the officer's firearm away from him. And in that situation, the officer's voice and pitch went up, the adrenaline hitting their system, they're out of breath. They don't sound necessarily like they do when you and I are having a conversation.
Right, right. And I don't necessarily sound like I'm sounding now when I get excited on the air.
Well,
you know,
I mean, that's true. I mean, it really, and you say that, but you probably have heard yourself on an audio where there was something passionate that was being discussed, or everybody here has probably heard somebody on a radio or on a phone and then met them and said, "Boy, they look a lot different than I would have expected them to sound.
Absolutely.
Their voice is not as deep, or it's higher than I thought." Well, when you put stress and adrenaline in there, it becomes a real big issue.
All right, let me ask you, in your experience, when the defense gets up here tomorrow and counters point by point what the prosecution has just said in summation, or in closing arguments, I should say, do you believe that a jury, as it's constituted, as for what we know of the jury, all female, many with children, at least a few gun owners, do you believe that they will be persuaded by the defense?
I think, quite frankly, they will, and I think you have to break that down very quickly. Second-degree murder, I think, is probably out the window. The jury has not heard specific evidence, and in Florida law, the words that they use is a depraved mind regardless of human life.
Right.
I don't think they've heard that. So the question is whether or not they fall back on manslaughter. The third-degree murder charge is essentially a felony murder. You were committing a felony, and a death occurred. I think that's a stretch. If he was in possession of the firearm illegally, or he was in a place he wasn't supposed to be, that might be an issue. But I think the real hurdle for the defense is manslaughter, and I think he stands a pretty good chance of being acquitted.
You know, I think if the jury knew, and they don't, if the jury knew that manslaughter carried a 30-year prison term possibility, they would also say no way. Because I think these people would probably like to be able to send them to jail for like a year or two, you know, if they had their druthers. But I'm just afraid that they might think they have to find him guilty of something, and they only have two choices. Unfortunately, they have two choices. They should have had the one, and then they could have justified saying no, and that would be it. But now they've been given the second choice, the lesser choice, quote unquote. But the lesser choice is really, you know, not all that much better. It could be 30 years, and if they knew that, I think that they would. There's no way they would do it.
Well, you're absolutely right, and the quirk of Florida law is, and it's probably the case in a lot of states, that the manslaughter carries a different penalty, but it has aggravating factors, one by the fact that Trayvon Martin was under 18 at the time he died, and second, that a firearm was involved.
Right.
So it is true. He could actually face a longer prison sentence if he is convicted of manslaughter. But, you know, the reason the juries don't generally know the sentences really has a lot to do with their role should be. And in my experience, juries really try hard to get to the facts and then apply them to the law as it's explained to them by the judge. So if you complicate that by saying any more than you heard the facts, the jury is the fact finder in the case. You heard the facts, you heard the witnesses, you decide what actually happened, and you applied it to this set of laws. Throwing in there the whole mix of penalties really is, first of all, too much, and second, would cause another problem. Because in order to actually sentence somebody, the judge usually will look at the person's criminal history. And the criminal history is, with very, very few exceptions, not within the purview of the jury to know when they're deciding the facts of the case.
Right. Yeah, no, very, very, very true. All right, so we'll see. I look forward to talking to you again. Lance, thank you very much for coming on short notice, sir.
Well, I appreciate if people would like the book. It's available on Amazon.com or WhenCopsKill.com. And, Steve, I enjoy talking with you.
No, and I just want to follow up on the book now that I'm glad you mentioned it again because, you know, so many times, and the reason I asked you about New York, I mean, we're obviously heard and seen all over the world, but I'm from New York, and I've talked about many cases where cops have used their guns, where right away the public likes to jump on them and convict them. You know, Amadou Diallo case, for instance, and others. So I've talked about many cases, and you know, people don't understand, and I'm sure this is all in the book, and I'm anxious to see it myself. So if you could have I'll talk to Mark, and we'll get a copy over here because I'd love to read it. You know, police officers are charged with making split-second life or death decisions, and if they hesitate, I mean, you know the slogan, "I'd rather be tried by 12 than carried by 6."
Well, I'll put it to you this way: officers usually have the rest of their life to decide whether to use deadly force. And there's a lot of interviews in this book. One of the interviews is with a retired Special Forces soldier who has seen more than his fair share of combat, and he's also a cop, a retired cop. And he actually told me that in his estimation, it is more stressful to go through an officer-involved shooting as a law enforcement officer than anything he ever did in the military. Because in the military, he expected combat.
Right.
Law enforcement officers are going about their duty in routine calls. Some of them are a little crazy. They're expecting a little bit of a problem. But generally, their adrenaline goes from 0 to my life is in danger within a nanosecond. And that's what When Cops Kill is about. What happens after that? What can they expect? And how do we take care of them after they get through a shooting like this?
Yep. And I'm not surprised that your subject of your interview said that, because in the military, you're expected to kill the person you're confronted with. You're expected to shoot them. There's not an inquiry of a grand jury every time. Not yet. Obama's trying, but you're expected to kill your enemy. But a police officer, and rightfully so, every time they use their lethal force, there's an inquiry, and there should be. But they have the toughest job in the world. All right, Lance, thank you very much, sir.
Thank you, Steve.